Thank you very much. It's also my pleasure to be here and discuss with you an issue that we consider all to be yet another expression of the prejudice and stigma that is affecting people living with HIV, but also an expression of the continuation of the environment of prejudice, fear, and lack of understanding around HIV 30 years into this epidemic. I'll be talking about the overly broad criminalization of HIV non-disclosure, exposure, and transmission, specifically discussing this document, which is a new guidance note that UNAIDS, working with civil society organizations, scientists, legal experts, has issued in June 2013. I'll be first talking about the problem, why UNAIDS decided to work towards the issuing of this guidance note. I'll be discussing the process of the guidance note, which is of particular interest, then presenting the content and some of the key recommendations that are made within those guidance notes, before talking to some recent developments that show that, in fact, hope is possible, yet we are still faced with many challenges. This map shows the global picture of criminalization of HIV non-disclosure, exposure, and transmission worldwide. We consider that at least 61 countries have laws that specifically criminalize HIV non-disclosure, exposure, and transmission. 1/3 of these countries are in Africa. In the United States of America, more than 30 states actually have laws that specifically criminalize HIV non-disclosure, exposure, and transmission. Most of the known prosecutions in this area appear to have happened in the global north. The United States of America leading globally with the highest number of individuals who have been prosecuted for exposing sexual partners to HIV mainly, and in many cases without any evidence of actual exposure. Then come countries like Canada, Sweden, Australia, and many others. But why are we so concerned? And this map really shows again that this is not a local or regional problem. It is a problem that affects all over the world. And the darker blue colors represent the countries where we know that there are laws that specifically criminalize HIV exposure, non-disclosure, or transmission, or countries where we have records of actual prosecutions that have happened under such legislation or under existing criminal law provisions. But why are we so concerned about the use of the criminal law in this area? We are concerned because the use of the criminal law in the context of HIV, as I was saying earlier, is a continuation of the lack of understanding the misguided policies around HIV. Because these laws or these prosecutions, where they do occur, clearly disregard the science of HIV. We have a number of records of prosecution that have happened, particularly in the United States, where individuals were actually found guilty and sent to jail for biting or spitting to another person. We all know that there have been no recorded cases of HIV through spitting, because in fact, HIV cannot be transmitted this way. There have been prosecutions in the absence of actual exposure or transmission. There have been prosecutions in spite of people also using condom or having a low viral load. The evidence at our disposal shows the benefit and effectiveness of condom in reducing the likelihood of HIV transmission. We all know that people with low viral load or suppressed viral load who adhere to the treatment have no evidence of sexual transmitted infection, have a much lower likelihood of transmitting HIV, and recent studies have actually confirmed that such individuals almost have a zero risk of transmitting HIV to the sexual partners, yet the prosecutions that are happening across the world are disregarding such scientific evidence. We are also concerned about the use of the criminal law in this area because they disregard basic legal principles that any of us will expect to be upheld by the courts, are disregarded every time it comes to HIV positive individuals. People are prosecuted without any evidence of mental culpability. There is no proof that an individual A transmitted HIV to an individual B, yet the person is found guilty. The penalties that are applied when people are prosecuted are particularly disproportionate. Some people being sentenced for 25 years in jail, even where the sexual partner did not become HIV positive, which means that there was no transmission. And we know of some legislation where the penalty goes all the way to death penalty. It's the case in the state of Lesotho in Southern Africa. We are also concerned about such legislation because of the impact on the HIV response. Recent studies conducted in Canada actually demonstrate that because of the fear of prosecution, many individuals feel afraid to engage positively with the healthcare workers. People living with HIV are afraid to talk about the sexual practices with healthcare workers because they're afraid that such record of generally confidential conversation with healthcare practitioners can actually be used in the context of criminal proceedings against them. So in the background of all those concerns relating to criminalization, there was then a need to try to come up with clearer guidance. And the need to come up with clearer guidance on the issue was made even more important by some conflicting judicial decisions that we have recorded over the years. For instance, in 2009, a court in Switzerland decided that an individual who was on effective antiretroviral treatment could not transmit HIV to a sexual partner and decided to acquit the person on the basis of effective HIV treatment. Yet, in 2012, in Canada, the Supreme Court felt that being on antiretroviral treatment was not enough and that still there was remaining a possibility of transmitting HIV to a sexual partner and required that people be both on effective HIV treatment with suppressed viral load, but also that they use condom. So an additional requirement showing the conflicting sort of judicial decisions. There have also been some legislative developments, some of which were pointing in the right directions, others actually going backward. We've seen some development in the United Kingdom where prosecutorial guidelines were adopted to clarify in which context the criminal law can be used. And we've also seen, and this is what makes this issue so particularly significant, the voices of civil society organizations. There have been a number of networks that actually stood up and started challenging the application of the criminal law in the context of HIV. Because when you talk of this issue, it is portrayed as if we are talking about individuals who intentionally transmit HIV to others. But the reality is that we are not talking about that. The reality is that in many cases, these prosecutions are not related to intentional transmission. They are related to acts that represent no risk. And the voices of criminalization survivors has been particularly important in bringing this issue to the fore. Many of such criminalization survivors are here at the conference. Individuals and colleagues like Nick Rhodes, Sean, many others who have worked on these issues are here at the conference, and I hope that you'll be going to the other events that are related to this issue to engage with them. So against this background, UNAIDS, on the suggestion of some colleagues working on this issue, decided to adopt a new guidance note that we hoped was going to reconcile the science and the law in the context of HIV. And this guidance note is a result of a 2-year project that took place between 2010 and 2012. The project was first supported by some research and evidence papers, and the research and evidence papers focused on trying to bring together the science of HIV risk, HIV harm, HIV transmission, and also bringing together the evidence in terms of what are the legal principles and how should the criminal law be applied in the context of HIV. And in August, from the 31st to the August to the 2nd of September 2011, there was a scientific consultation that was organized in Geneva, and the photo that you have on the screen is that of Brian Gazard, who is a leading scientist and clinician, HIV clinician in the United Kingdom, and Justice Michael Kirby, who spoke here at the opening ceremony. And these two individuals actually characterize and illustrate the attempt that we try to achieve at that scientific meeting was to bring the expert in the science of HIV, but also the leading voices globally in terms of human rights and legal principles, and ask them, what do you think of the current application of the criminal law in the context of HIV? And they help us in developing a number of considerations and recommendations that we took forward at a political and policy consultation that took place in February 2012 with the support of the government of Norway. And this is an opportunity for us to thank and congratulate the government of Norway for its help for this work, because it was also an issue that was current in Norway, but yet they decided to provide UNAIDS with finances to actually look into this issue. And at the end of this process, UNAIDS issued this new guidance note, which makes 3 basic points. The first basic point is that the criminal law in the context of HIV should be restricted to truly blameworthy cases. And these truly blameworthy cases are cases of intentional transmission, which is when an individual knows that they're HIV positive, decide to enter into a conduct which they know represent a risk of HIV transmission, and actually do transmit HIV to another person, and doing so intentionally. The second principle that the guidance note makes is that in any application of the criminal law in the context of HIV, criminal justice principles of foreseeability, of proportionality, and other principles should be upheld. The third basic point that the guidance note makes is that the best scientific and medical evidence should guide any application of the criminal law. Hence, people should not and cannot be prosecuted for acts that represent no risk, such as spitting or biting, when people use condoms, when people are on effective HIV treatment or have a low viral load. And the guidance note goes in details to actually address a number of issues, including the harm of being HIV positive or transmitted HIV. And on that particular issue, the guidance note makes it clear that there should be no form of criminal liability where there was no transmission of HIV. The guidance note also speaks to the fact that there should be no criminal liability when the act of the person living with HIV implies no risk. So when people use condom, there should be no criminal liability, and for other acts, such as acts that are generally known to represent no risk of transmission. The guidance note also requires that before any criminal offenses or any criminal prosecution be brought against an individual, there should be the proof that, in fact, they had an intentional mindset and wanted to transmit HIV. The guidance note speaks to the issue of defenses and makes it very clear that any person who is being prosecuted in relation to HIV non-disclosure, exposure, or transmission should be able to use as a defense the fact that either they disclose the HIV status before a sexual act, they should be able to use as a defense the fact that they use condom, they should be able to have as a defense if they had a low viral load or if the person was on effective HIV treatment. The guidance note also requires that elements of proof exist, and that there should always be a proof that an individual transmitted HIV to another person before they can be held accountable and found guilty. And then finally, the guidance note addresses the issues of penalty and asks that any penalty applied in the context of HIV criminalization should be proportionate and no different from similar penalties in other issues. And since the publication of this guidance note, but also before the publication of this guidance note, we've seen a number of progress, including in terms of legislation in Africa and elsewhere. We've seen some positive court decision. We've seen the adoption of prosecutorial guidelines, which are very important, and many groups across the world, in Canada, in other jurisdictions, are working towards the development of prosecutorial guidelines, which are very useful tools that tell prosecutors in which case not to use the criminal law law, in which case not to bring prosecutions against individuals. Another positive development that we believe was actually further elevated by the process of developing this guidance note is that we are seeing an increasing collaboration between scientists, clinicians, and advocates that are working against criminalization. And recently, in Canada, there was the issuing by a number of leading scientists of a consensus statement on HIV and its transmission in the context of the criminal law. And among those who actually led the development of this Canadian consensus statement was Professor Rio Montagnier, Catherine Hankins, and others who are leading scientists and recognized across Canada for their work. And this very much opens the new realm of collaboration between human rights experts, between clinicians, between public health specialists, but also with people living with HIV, to push in the direction of ensuring that we can create a new collaboration against the overly broad application of the criminal law in the context of HIV. And I wanted to end by reminding ourselves that as we gather here today, we know that there are many people across the world who are sitting in jail just because the society, the legal system has failed to do them justice because of fear and prejudice. And among these people, there is Rosemary Namiburu, a nurse from Uganda, who because of the fear of HIV, because of the prejudice relating to this epidemic, was held accountable, was criminalized and found guilty for exposing a child to HIV. And Rosemary, a 64-year-old nurse who was trying to help a distressed child, trying to provide him with an injection, is today sitting in jail in Uganda, and she will be there for 3.5 years if nothing is done to take her out of jail. And the case of Rosemary reminds us also that across the world there are many other individuals who are suffering from the power of fear and are not receiving the justice that they deserve. I want to thank you, and unfortunately I will not be able to stay to take questions, but again I would like to encourage you to engage in the various events that are taking place during this conference around the criminalization of HIV, non-disclosure, exposure, and transmission. As I said earlier, there are a number of HIV criminalization survivors at this conference. I hope you can meet and engage with them. There are some great networks that are working against criminalization. The GNP Plus is one such network, and I want to take this opportunity to congratulate and thank them for their work. The HIV Justice Network, led by my friend Edwin Bernard, doing fantastic work to bring this issue to the fore and ensuring that we do not forget that this is an issue that is yet another expression of stigma and discrimination. I want to thank and congratulate the Canadian HIV/AIDS Legal Network for the work that they are doing in Canada, and many other groups across the world, my friends in Kenya, in Zimbabwe, and across the world that are working on this issue. Thank you very much for your attention.